Good day. Welcome to IOLTA in the U.S. Virgin Islands. My name is Casey Payton. I am the Executive Director of the VI Justice Initiative. We are a 501c3 nonprofit organization providing free legal representation. We focus on economic justice and poverty law. I first got involved in the Virgin Islands IOLTA when I joined the IOLTA board last year. And then I had the opportunity to go to the ABA NAPE National IOLTA Conference in November 2023. I was invited by my co-presenter, attorney Amaris Torres, and you're going to hear a little bit more about that. But I would like to let her introduce herself as well.
Hi, good afternoon. I'm attorney Amaris Torres-Rivera. I'm currently the executive director at Fundación Fondo de Acceso a la Justicia, or Access to Justice Fund Foundation. We are a nonprofit organization in Puerto Rico and administer the IOLTA program as well. I am also a member the board of the National Association of IOLTA Programs, and currently chair the Racial Lens Working Group and also part of the Racial Justice Committee at NAPE. Thank you for having me.
We're going to dive right in. So what is IOLTA? IOLTA stands for Interest on Lawyer Trust Accounts. And that is very important to understand this presentation. And so we have the definition here on the PowerPoint. And an IOLTA account is very similar to any lawyer trust account that attorneys are required to have. However, this is going to be an interest-bearing trust account, and the interest on it will be, it goes to the IOLTA board, and it's given to for furthering access to justice and civil legal aid. And so how this came about is that about 40 years ago, there was a determination made in the States where the money that a client puts into a lawyer trust account, the client isn't really expecting and doesn't have a right to that interest, and neither does the attorney who's holding it for the client. This was upheld in a U.S. Supreme Court case that we have on this slide, Brown v. Legal Foundation of Washington. And so what happens to that interest? Because it can grow pretty rapidly, especially if you're considering all of the IOLTA accounts, the lawyer trust accounts across the Virgin Islands. Well, that money can be used to further access to justice. It can support people who cannot afford an attorney and who need an attorney for civil legal services. What type of funds are we talking about? What type of funds go into an IOLTA account? Well, these are generally nominal in amount or are reasonably anticipated to be held for a short period of time. And so these are the funds that usually go into a lawyer trust account. Here are some examples of the types of funds that could be placed in an IOLTA account: earnest money, loan proceeds, settlement proceeds, collection proceeds, cost advances, and advance payments of fees that have not yet been earned. You may ask yourself, where is IOLTA in VI law? And I wrote it that way because actually in the Virgin Islands, IOLTA isn't created by law. It is in some places, but here it's actually under the VI Supreme Court. And so that is very different from our other presenter, who is going to be discussing the Puerto Rico IOLTA, because that one is actually created by law. And in the States, it's about 50-50 or so. Some are created by law, some are created under the Supreme Court. So today we're going to be discussing the VI Supreme Court rules, the VI rules of professional conduct, briefly on the ABA model rules, and also the VI rules of civil procedure. If you don't know, Rule 211 of the VI Supreme Court rules created the VI rules of professional conduct. So they are housed under the VI Supreme Court. And here we have a side-by-side. On one side, we have a VI Supreme Court Rule 211.1.15. And then on the other side, we have the ABA model rule that it was created after. And so when you look back and forth from side to side, you can see that it is pretty much identical. Go to the next slide. Now we're going to talk just briefly about the client trust account requirements. And so this is still under the VI Supreme Court rules, the VI rules of professional conduct. And they explain that every lawyer in private practice in the Virgin Islands must comply with these rules by maintaining in the lawyer's own name or in the name of the lawyer's law firm a trust account. Okay, so this is the part under Supreme Court rules where you can find the rules about trust accounts. This presentation is not going to be all about trust accounts. We're actually going to be talking about some of the special things about IOLTA. But if you have any questions about what is required of a lawyer trust account, you can look at these rules and obviously ask questions to the Office of Disciplinary Counsel. And it continues by saying that one or more of the lawyer's trust accounts may be an IOLTA account, a VI interest on lawyer trust account. It also provides the definition of IOLTA. And so an IOLTA account under the Supreme Court rules states that it's a pooled trust account for funds of clients or third persons that are nominal in amount or expected to be held for a short period of time. So that's the same definition that we had earlier. And if you're wondering who receives the interest under the Supreme Court law, it says that interest or dividends paid on an IOLTA account shall be paid to the Virgin Islands Interest on Lawyers Trust Account Board, and the lawyer and the law firm shall have no right or claim to such interest or dividends. I'm going to jump into something a little bit different, but it's important because it's also under VI law, and that is cypre. And I think that a lot of folks may have an idea of what cypre is, but may not be too familiar. And we're specifically talking about cypre and class actions. And so the definition we have here is that cypre is a doctrine that permits a court to award any unallocated, unclaimed, or undeliverable funds from a settlement or class action to a nonprofit or IOLTA. And where we can find this in VI law is this is Rule 23 of the VI Rules of Civil Procedure. This is a fairly new rule. It came about in 2020 or 2021. And this rule provides the mandate of residual funds from a class action after payment of all class members' claims, expenses, litigation costs, and attorney fees, for the court to direct notice regarding the distribution of these funds to any parties, anyone identified by the parties or the court, including any nonprofit entity that promotes access to justice for low-income persons. So what are we talking about here? We're talking about in a class action when the money comes down, you're trying to pay out all of the members of the class. There are inevitably going to be some class members either who cannot be found after a reasonable time, or who decide they don't want the money. And so there's always a possibility that that could actually go back to the defendant if it's unclaimed funds, residual funds. However, there is an opportunity for the parties in the class action to decide earlier on, okay, if there are any residual funds, where are they going to go? And this presentation is about how, those funds could go to the VI IOLTA to be used to further access to justice. That's a great spot for them. It makes sense, right? Because in a class action, it's important to find a nexus between, the folks who were harmed, and it it just really makes sense for these funds to go to an IOLTA or to go to another nonprofit, a legal nonprofit. And that can be decided, like I said, by the parties or identified by the court earlier on in the case. We're going to jump into these national organizations because they were really what connected me and my co-presenter and brought all of these wonderful ideas down to the VI about how we can increase access to justice by improving our IOLTA programs and by bringing in more funding. And these are some tried and true methods. So I'm going to discuss briefly the ABA IOLTA Commission, and then I'm going to hand this presentation over to my co-presenter to talk about NAEP. The ABA IOLTA Commission, now this is part of the American Bar Association, and it supports the operation of IOLTA programs nationwide. And why this is important is because they do, among other things, they have a national conference. And so it was the one that I went to was in November 2023. And I was invited by my co-presenter. I actually got a scholarship because there was an interest in bringing more territories to the room, to the table at the conference, because Puerto Rico historically has been the only territory that has participated in this conference. And I can't tell you how wonderful it was to be a part of this conference, because they had representatives from IOLTA programs all across the nation, and we were able to organize by kind of by type or by the amount of money that each program brings in. And that was how I learned that our IOLTA program could be much bigger, and it really could be the mechanism that brings a tremendous amount more resources down to the Virgin Islands to provide funding for civil legal aid, to provide free attorneys for people who cannot afford them. And this was the conference where I had that realization. I'd like to now turn over the presentation to my co-presenter to start discussing the other national organization that helps IOLTA programs.
Thank you, Attorney Payton. So the National Association of IOLTA Programs is a nonprofit, nonpartisan membership organization. All of its members are funders for civil legal aid, and currently Puerto Rico is the only U.S. territory that has been part of NAEP for the past recent years. But also there are other U.S. jurisdictions, the states, the Washington, D.C., and also Canadian provinces. Like Attorney Payton said, this year, this November conference was particularly important because the almost 60 members of NAEP were able to discuss relevant issues on IOLTA programs. They were able to discuss national trends. And in particular for Puerto Rico, I was able to bring racial justice issues in our IOLTA programs that matter to us, specifically with the inclusion of U.S. territories to this collective, to this organization. In a sense that it is also about inclusion, it is also about racial equity. Our territories, our islands are mostly people of color. So we definitely feel that we not only need to be in the table, but also have a voice. Obviously, our people from our islands and territories need access to justice. In the case of Puerto Rico, it's a 3.4 million population with approximately 44% of people living below the poverty rate. So access to justice is definitely an issue. for us. So, bringing this to NAPE at this conference was particularly very important. So I'm very happy that Attorney Payton was representing VI at that conference, and eventually the inclusion of more U.S. territories. But NAPE has also been very important for our program since it's basically started between 2013 and 2017. So it's a very recent program, small program, but it has had the mentorship of not only NAPE, but also members such as the Texas Access to Justice Foundation, and other colleagues from Oregon and other states have been incredibly helpful in providing guidelines to our program, ideas on how to structure our program, ideas on creating, for example, emergency legal aid funds, which have been incredibly helpful particularly after Hurricane Maria in 2017, and we've been sustaining that fund. So it's definitely a collective, a very important collective for IOLTA programs, and I definitely recommend membership for any IOLTA program. And we are all funders of civil legal aid, so we definitely the work that we do with our grantees has a very great impact in all the United States and US territories. Next slide. Okay, so I'm currently a member of the Racial Justice Committee and currently chair the Racial Lens Working Group at NAPE, which are very important initiatives because unfortunately, the majority of the attorneys in the United States, especially working with the access to justice ecosystem at a board level or staff, attorney staff in their nonprofits, in their grantees, are mostly white attorneys. But the population that we serve and that need access to justice are people of color, are women, are Hispanic most of the time. So that diversity we don't get to see with the people that provide the service or the board or attorneys, but yet that is, the population that we serve. So it was very important for me as a member of these committees and chair of this new working group, not only to diversify and promote racial equity in these spaces, but also make folks at NAPE aware of how important this is. Because sometimes, unintentionally, they don't necessarily know the importance of having voices and representation in these spaces, especially because it helps us also be more efficient in the service and in our grant making process as funders for civil legal aid. So really quickly, three things that we have several accomplishments, but very quickly, three accomplishments that I want to point out is that since this groups were created, racial justice webinars or racial justice issues have been yearly in conferences and like I said, in webinars. At the November 2023 conference that Attorney Payton mentioned, I was able to coordinate together with two colleagues of Mexican heritage, the first all Hispanic panel about racial justice and disaster relief. I was also one of the panelists, so that was very important and a historical step for diversity and inclusion at this NAPE level. And also, a third accomplishment that I would like to point out is the progress that we've made of language and inclusion of US territories. So I want to talk a little bit also about Next slide. I already addressed this. Okay, so I want to talk a little bit about the Puerto Rico IOLTA program. Next slide, please. So Puerto Rico IOLTA, like Attorney Payton mentioned, was created by law. And this is very important because currently there are different models of IOLTA, like Attorney Payton said, ones are created by Supreme Court, others are a part of bar associations or bar foundations, others are created by law. In the case of Puerto Rico, it was a law enacted in 2013. And when it was created, the Access to Justice Fund and the IOLTA mechanism for attorneys was available because of this law. But we didn't have any money at that time, right? So it was a work in progress. You know, it was hard at the beginning, but we were able to, because of the structure that eventually we created and the staffing necessary for this program, we were able to access important settlement funds, specifically the Citibank and Bank of America case. That settlement was a very $1 million across the nation settlement. And its focus was targeting the IOLTA programs and providing those funds to IOLTA programs. And Puerto Rico, at that moment, already our IOLTA program was created. So approximately between 2015 and 2016, we were able to receive $12 million to our IOLTA program from that settlement. So what I was expressing to Attorney Payton at that in the past week was that the importance of IOLTA programs, not only receiving the interest from the accounts, but also it allows you to receive other funds from settlement funds or from SciPray, because you become a strong, important funder for civil legal aid, right? So in the case of Puerto Rico, although we have from 8,000 to 10,000 active attorneys, as you can see from the slide, we currently only have 180 IOLTA accounts open. This includes law firms and solo practitioners. And, you know, obviously our goal is to have much more IOLTA accounts opened. Currently we've only received approximately $136,000 from interest from our IOLTA since 2017. So there's not much revenue coming from our IOLTA accounts. But also, it has made us view what other ways as a program, what can we do to seek other funding. So we have private funding as well, but to make our program sustainable, what the board of our program decided was that, for example, the 12 million settlement fund, we would invest it. So that decision of investing those funds would make and also a limit on how much funding for grants every year, right? We give to grantees. So those decisions were important to make our program sustainable. And so far, it has been a great success. In the case of Puerto Rico, also, it started in 2013 with the law. The language was mandatory for every attorney that received client money to deposit that money in an IOLTA account, not an escrow account or not a checkings account, but an IOLTA account. There was that obligation. Right now, the law was amended and it included a sentence that states that the Supreme Court of Puerto Rico will decide which attorney that receives funds from clients will or not have to open an IOLTA account. So in that sense, we have sort of like a hybrid system. Ethically, there's an obligation because of our code of professional ethics that attorneys put their client money in IOLTA and not mix them with their personal property. So in that sense, there's that obligation. But with our law, it became sort of like a voluntary program. So definitely new IOLTA programs like VI and others, eventually I would encourage them to definitely have a mandatory program, not only because it will help have revenue from the interest generated by IOLTA accounts, but also because it helps ethically lawyers to have their client money not mixed with their personal property, and that could be a really huge issue in Puerto Rico, ethically speaking. So it also helps in that sense many attorneys. So one of the similarities of VI and Puerto Rico is that we also have the same 3 banks. So in that sense, when talking to Attorney Payton about our program being recent and their program being starting and being pretty much new as well, we definitely feel that as U.S. territories, together, we can definitely be more powerful with not only a voice to speak to banks and honor good rates for IOLTA accounts, but we can definitely have an exchange of knowledge on what works and what not works for IOLTA programs and civil legal aid in general in our territories. Next slide. Okay.
Okay, so now we're going to discuss a little bit about the national trends in IOLTA and some of the ideas that can increase the resources for the U.S. Virgin Islands access to justice through our IOLTA program. And I think it makes sense just to kind of start at the top and make our way down, even though banking rates are something we definitely want to talk about. So at the ABA NAPE IOLTA conference, they discussed that there is a desire to amend the ABA Model Rule 1.15 to clarify where lawyer trust accounts should be kept. Because currently in the ABA Model Rule, and similarly in the Virgin Islands Rule of Professional Conduct, which mirrors the ABA Model Rule, it's not too clear. And as we know in the Virgin Islands, even though there is a lot of money passing through the Virgin Islands through lawyer trust accounts, because we have such a large off-island VI attorney population, it can be tricky to determine where those IOLTA accounts should be held. And so where is the interest going to go? And so let me give you an example. Perhaps somebody practices their offices in Florida, but the majority of the work that they do is in the Virgin Islands. Would they keep their IOLTA account in Florida or in the Virgin Islands? Similarly, there's a lot of major national law firms who have 10 or more attorneys regularly practicing in the Virgin Islands, many of whom are admitted to practice in the Virgin Islands, yet those big firms may keep their IOLTA accounts wherever their headquarters are. They have a lot of different offices. There are very few large law firms who have brick and mortars in the Virgin Islands. And even those, this may not be their national headquarters. And so the ABA IOLTA Commission has decided it's important to make this a little bit clearer about where lawyer trust accounts, IOLTA accounts are kept. And hopefully the Virgin Islands will get to have a seat at that table and the other territories, because it really will affect our IOLTA accounts if that language is changed and clarified. Should we jump to the next one where it talks about unclaimed funds at the court?
Yes, definitely. So unclaimed funds at court in the case of our program in Puerto Rico was a language included in our law. This is very, very important because we recently received a little bit more than $200,000 from unclaimed funds. And this was very important because our program with that money, we created a gender violence program and was able to fund several nonprofit organizations to provide civil legal aid for gender violence victims and survivors here in Puerto Rico. So also not only at a state court level, but also at a federal district level, it is important to have at both, right, at both jurisdiction court levels, to have that type of language, because it could definitely go to the program and translate to civil legal aid. We were able to present as well a motion in in a settlement recently at the Federal District Court in Puerto Rico and received money as well from unclaimed funds. So that could definitely, as well as Cypre, I'm going to also talk a little bit about Cypre. Cypre, that was actually what we did with the motion that we presented at the Federal District Court. So we have those two mechanisms in Puerto Rico, where we definitely have received funding from those sources. And as I mentioned in the previous slide, since Puerto Rico is a small program and it's been starting and we only have 180 accounts, definitely these type of funding streams for our program are vital. Without these streams, our IOLTA program would not have funding for civil legal aid. So that's why it is important to see IOLTA programs, you know, at a level, and I know that Attorney Payton saw this at the conference, the diversity of IOLTA programs currently. There are maybe like 20 programs that most of their funding is not even IOLTA, right? It's not even an IOLTA source. It's part of the entity, but it's not in its entirety. It's not from IOLTA funding. And that's, I think that's also the beauty of it as well. It's seeing everything as a system, as a civil legal aid system, where different sources of funding help us with what's important in the end, which is service and access to justice to communities that have been historically marginalized, that suffer poverty, and have been historically violated of their rights. So, you know, at the end, that's what's important. And in the case of our program in Puerto Rico, once we established the structure and the staffing and our policy guidelines, because we do have regulations, we have policies, we have a grant management structure as well. Currently, we have 5 staff members, including myself. So in Puerto Rico, we currently have 33 projects, legal aid projects, with different grantees. And we have 5 principal or top programs. We have the mortgage foreclosure prevention program. We have the general civil family law, administrative law program. We have the economic community development program. We have a fellowship as well, which we fund a young lawyer that presents a proposal for an access to justice project. And we also fund that for a year. We also fund that young lawyer. So we have that fellowship program. And the other program is the disaster legal aid program, which has been um intense after these two or these three, Irma, Maria, and Fiona, this past year in 2022 hurricanes, and also in Puerto Rico we had in 2020 earthquakes as well. So it's a program that continued to expand, but that's part of what IOLTA could become. It could become, a solid structure with diverse programs, depending on the necessities of the territory, depending on the necessities of the people and the communities that live there, right? So, it's important to mention how the structure is in Puerto Rico, because all of that could not be able to work without other sources of funding other than IOLTA. And that's why we wanted to talk a little bit about unclaimed funds, cypre, and other sources of funding like settlement agreements as well.
I'm so glad that you talked about the structure of the Puerto Rico IOLTA, because it really shows us that when we're talking about an IOLTA program, we're talking about a charitable foundation. And if we think about it the way that other charitable foundations are run, they have the ability to make decisions about how to grow the foundation and to make the foundation sustainable for a longer period of time. And when it comes to settlement agreements, this is something that the Virgin Islands is very familiar with. Over even the past year, we've had tens of millions of dollars come through our territory in the form of settlement agreements. And by introducing IOLTA as the proper as a proper recipient of a portion or a percentage of settlement agreements, especially when depending on what the underlying purpose of that settlement agreement is, but considering that we're assuming that the money should be used in part to further access to justice and civil legal aid for Virgin Islanders who could not otherwise be able to afford an attorney. It does provide a reasonable and necessary nexus to the underlying settlement agreement. And so if we're thinking about our IOLTA program as a foundation that can decide, how they want to send out the request for proposals, depending on the type of funding that's received, decide whether they want to do like what the Puerto Rico IOLTA did when they received the big Bank of America settlement and, provide a portion to the community and then invest it so that, thinking long term, how it could impact the community. This is something that I don't believe has been contemplated previously with the Virgin Islands IOLTA. Attorney Torres, can you explain how you were able to invest those funds and what it meant for the sustainability of your program?
Of course. So first, we created an investment policy that's very important for the organization to have that policy established. And then what was very important as well was to establish a limit, right? Considering the return of investment and the rhythm and the pattern that we were seeing with the investment, which is diversified. It's not in one place, it's diversified. So when we were seeing the rhythm of that investment, the board was our board was able to decide, okay, this is approximately what we will distribute in funding. And that has been currently the pattern so far. So yearly, from that settlement funding, we invest in grants approximately $800,000, sometimes 1 million, depending on how we see the legal necessities of communities here, but usually between 800,000 and 1 million, and it does not exceed. So that's key, right? So it does not exceed. And that's part of the sustainability. That's how it has worked for us. It has been a very successful model. We are also seeking other settlement fundings as well, because we already developed an expertise on receiving and managing and administering settlement funds. So from our perspective to government perspective or Department of Justice perspective, Attorney General, we have become an entity that has an expertise on receiving and administering settlement funding, and with our policies established, and we have also audits. We have internal audits, external audits, and that's very important. We have an annual report that we also provide to the governor in Puerto Rico, the Supreme Court justices as well, the comptroller in Puerto Rico. So there's a fiscalization and transparency structure very well established of how we use funds from different sources. And it's important also because attorneys also want to know. They want to know how their IOLTA, although it's not their money, it's their client, but they also want to know how it's being invested. And it's important for us to let them know how that IOLTA mechanism is so important. And it's so important that they open an account because it translates to such important services, legal services being provided. And also, one of the beauties I see from IOLTA is that we administer non-restricted funding in the majority of the cases. So, our grants or our grantees don't have a limit on providing legal aid to, migrant communities, or they don't have issues, for example, for class actions, as maybe other sources of funding have that restriction, for example. So, it's an important source of funding that does not have those restrictions necessarily. And it also helps us broaden the scope of work, of legal work.
All right, well, we have about 7 more minutes, and I think that it's important for us to cover IOLTA banking rates. And let's start off with just a little bit of perspective, though, because some folks might not understand how much money IOLTA programs bring in nationwide. And I know that, since 1981, over $4 billion has been, raised by IOLTA funding that goes towards access to justice. And at the conference that we went to, I was sitting at the table where the least amount of money was given out per year. I was at a table where all of the IOLTA programs gave out less than $5 million every year. And I think that Puerto Rico probably would have been at that same table for how much you give out every single year. And then the increments after that for the different groups, we were under 5 million, then it was 5 million to I think it was 15 million, and then 15 million to 30 million, and then over 30 million. And so all of these IOLTA programs that give out this many millions, tens of millions of dollars every year to access to justice, civil legal aid, they are really benefiting from this increase in interest rates. And we just kept hearing how they were, because interest rates have been at near zero for however many years, and IOLTA programs have been functioning. But now that interest rates are rising, it's just a windfall. And so many of them are saying, we can't spend all the money that we're getting, and we're starting to do an endowment and other rainy day funds. However, it's a little bit of a different situation for the territories and in other communities of people of color. And I was wondering if Attorney Torres, if you wanted to address that.
Definitely. So First Bank, for example, is one of the banks that is in Virgin Islands as well as Puerto Rico. And although it has been a bank, a very important bank in Puerto Rico, because it was the first bank to open an IOLTA and make it accessible to attorneys here in Puerto Rico, and that has been great. But in the past year, maybe two, because of my involvement in NAPE at a national level, like Attorney Payton said, I've been listening to all of these programs talking about high interest rates from Federal Reserve and from Wall Street, and everyone is benefiting from a 4, 5, 6% interest rate from IOLTA. And although 4, 5, and 6% sounds amazing and sounds great, for example, in Puerto Rico, that First Bank, which has been the main bank for IOLTA accounts, give us an interest rate of a 0.2%. So that's definitely an issue. It has been on a when you analyze it at a national level, it definitely is an issue, because we're not benefiting from the trend of high interest rates. And then, we wanted to know why, so we started making research about that. And it seems odd. It seems odd that specifically for the case of a U.S. territory such as Puerto Rico, the interest would be so low. It will stay low despite the national trends. And what's interesting is that our law in Puerto Rico, we have a comparability rule, which obligates banks that have IOLTA accounts here in Puerto Rico to give IOLTA accounts the highest interest rate in comparison to their, to any other product or any other banking product. So it's interesting to see that despite our comparability rule and despite national trends, the bank here is giving us that 0.2% in our IOLTA account. So it's definitely something that we are aware of, something that we're analyzing at a racial lens level as well, and something that VI should consider as well, because it's the same bank and we are both U.S. territories. So it's important to keep track of this trend, and obviously be an important voice to have just banking rates here in VI and Puerto Rico, as at a national level other folks are benefiting.
Well, that's something that we're going to continue to stay on top of, and I get the opportunity to be involved in the planning committee for the NAPE pre-conference at the Equal Justice Conference in 2024 in Detroit. And we're hoping that we can spend some time addressing this issue because it does feel like a disparity in banking interest rates that especially affects the territories. And so we'll have to see if we can continue to have a seat at the table, the U.S. Virgin Islands and Puerto Rico, in these national conversations with other IOLTA programs. All right, well, that just about concludes our presentation. I'm providing our contact information here if you have any questions or if you'd like to continue this conversation. You can reach us at this contact information provided. I want to thank my co-presenters so much. Thank you for coming down to the 2023 VI Bar Association annual meeting at the Westin in St. Thomas. I hope that our relationship continues as we continue to promote our IOLTA programs and see how much resources we can get for access to justice.
Definitely. Thank you. Thank you very much.